Now, the High Court. The High Court is the highest judicial authority in a state. The Parliament has the power to establish a common High Court for two or more states. High Court is the apex court at state level. It comprises of Chief Justice appointed by President, Governor of State and Chief Justice of the India. Then the number of judges are variable as per the size of the state. All the judges have the tenure till the age of 62 years. He can be removed from the office. Then, qualifications for appointment. First one, he must be a citizen of India. Then, he must have served as an advocate for 10 years at least in the High Court, or he must have served in the court for at least 10 years as a judge. Then he must be expert of a law. Functions and powers of High Court. The High Court is the highest court of the state. The Constitution empowers the High Court to issue directions, orders, or writs for the enforcement of fundamental rights and for any other purpose. Like the Supreme Court of India, it also enjoys the original and appellate jurisdiction. Original jurisdiction. A high court has original jurisdiction in certain matters like those involving fundamental rights, wills, matters relating to state revenue and its collection. Appellate jurisdiction. Appeals in civil and criminal cases can be made before the High Court against the decision of the Subordinate Court. The High Court can give fresh verdict in such cases. Then it controls and supervises the working of the lower courts. It is responsible for the administration of its own affairs as well as the affairs of its subordinate court. It also regulates the appointment of subordinate services in the lower courts. Subordinate courts. Each state is divided into various districts. The court which function in these districts are called subordinate courts. They hear civil and criminal cases which pertain to the district in which the court is formed. The courts that hear civil cases at the district level are called the district courts, and those that hear criminal cases are called session courts. Lok Adalat. The process of seeking justice is time consuming and expensive in our country. For these reasons, Lok Adalat or the People's Court was set up to provide speedy justice. A Lok Adalat is presided over by a retired judge along with two other members, usually a lawyer and a social worker. The disputing parties put forward their own cases without advocates. The cases are solved through mutual understanding. No appeal can be made against the order of Lok Adalat. FIR, a First Information Report, popularly known as an FIR, is generally a complaint of a cognizable offense lodged by the victim or by someone else on his behalf to the police. After receiving the information, the police prepare a written document which is called an FIR. It is very important document because it sets the process of justice in motion. A person giving information or making a complaint has the right to demand that the recorded information be read out to him. Once recorded, the FIR must be signed by the person who lodged it. It is the right of the lodger of the complaint to ask for a free of cost copy of the FIR. It must be written, date, place, time of incident must be there, and narrations must be correct. FIR has to be filed at the police station that is nearest to the incidents. Public Prosecutor. The underlying principle of the Indian judicial system is that All crimes committed by an individual or groups against others are deemed to have been committed against society. Consequently, the state takes action to prosecute the accused on behalf of and in the interest of society. This role is performed by the public prosecutor on behalf of the state. He is the government's legal representative who is responsible for presenting the case against an individual suspected of breaking the law. The public prosecutor's main aim is to play an impartial and neutral role and prosecute all persons who have been charge sheeted by the police. The prosecution cannot be part of investigation and police cannot direct or be part of the prosecution. A public prosecutor is an important officer of the state government and is appointed by the state under the Criminal Procedure Code. He is not a part of investigating agency, he is an independent statutory authority. PIL, Public Interest Litigation. Now, normally a person whose rights have been violated or who is involved in a dispute or has been a victim could move to the court of law. But a new concept underwent a change around 1980. The Supreme Court set the trend when it decided to hear a case where the case was filed not by the aggrieved person but by others on their behalf. The apex court decided to reach out to the people and hence it devised an innovative method wherein a person or a civil society group could approach the Supreme Court seeking legal remedies in cases where public interest is at stake. Justice P. and Bhagwati and Justice V. R. Krishna Iyer were among the first judges to admit PILs in the court. A PIL is a public interest litigation introduced in a court of law, not by the aggrieved party, but by any other private party or by the court itself. Such case may occur when the victim does not have the necessary resources to commence a litigation or his freedom to move has been encroached upon. The court can itself take cognizance of the matter and proceed, or cases can commence on the petition of any public spirit person. Filing a PIL is not as cumbersome as any other legal case. There have been instances when even letters and telegrams addressed to the court have been taken up as a PIL and heard by the court. So, students, I hope you understood the chapter well, and thank you and have a nice day for today. We'll continue with another chapter in the next lesson. Thank you.